네, 그럼 지금부터 2012 오픈소스 소프트웨어 라이선스 인사이트 국제 컨퍼런스 본행사를 진행하겠습니다. 저는 오늘 이 뜻깊은 자리에 사회를 맡게 된 아나운서 황정입니다. 여러분들 안녕하세요. 만나서 반갑습니다. 네, 문화체육관광부가 주최하고 한국저작권위원회가 주관하는 2012 오픈소스 소프트웨어 라이선스 인사이트 국제 컨퍼런스에 참석해주신 여러분들께 먼저 감사의 인사 말씀을 드립니다. 아울러 여러 전문가분들을 모시게 된 점 역시 굉장히 개인적으로 영광으로 생각을 하는데요. 2010년 이후 매해 열리는 본 행사는 오픈소스 소프트웨어 라이선스 인식 제고와 또 올바른 오픈소스 소프트웨어 이용 문화 정착을 위해서 정착과 산업의 현재와 미래를 함께 조망해보는 교류의 장으로서 자리매김하고 있습니다. 이번 국제 컨퍼런스는 국내뿐 아니라 미국과 인도 소프트웨어 프리덤 러 센터의 인사분들을 초청을 해서 오픈소스 소프트웨어 라이선스의 최근 해외 동향과 함께 주요 쟁점 그리고 각국의 거버넌스 구축 사례를 들어보고 또 국내 오픈소스 소프트웨어의 현황과 라이선스의 향후 쟁점 및 거버넌스의 발전 방향에 대해서 다 함께 논의하는 장이 될 예정이고요. 여러분들 끝까지 함께 하셔서 여러분들에게도 아주 유익한 시간이 되기를 바랍니다. 그럼 지금부터 2012 오픈소스 소프트웨어 라이선스 인사이트 국제 컨퍼런스 본격적으로 진행을 해보겠습니다. 먼저 바쁘신 와중에도 오늘 귀한 걸음 해주신 우리 내빈 여러분들을 소개해드리겠습니다. 한 분 한 분 소개해드릴 때마다 여러분들 큰 박수로 환영을 해주시기 바랍니다. 자, 먼저 문화체육관광부 문화콘텐츠산업실의 우리 박순태 실장님 자리해주셨습니다. 네, 어서 오십시오. 네, 다음은 한국저작권위원회 유병환 위원장님 자리해주셨습니다. 어서 오십시오. 네, 다음은 소프트웨어 프리덤 러 센터 에벤 모글렌 대표님께서 자리해주셨습니다. I'd like to introduce Mr. Eben Moglen. Please welcome him in your round of applause. 여러분들 큰 박수 부탁드리겠습니다. 네, 다음은 소프트웨어 프리덤 러 센터 인도 지부의 우리 미시 카우드하리 지부장님 자리해주셨습니다. 네, 다음은 사단법인 한국공개소프트웨어협회 송상효 회장님 자리해주셨습니다. 어서 오십시오. 네, 다음은 충남대학교 법학전문대학원 이철남 교수님 자리해주셨습니다. 안녕하십니까. 어서 오십시오. 자, 마지막으로 대통령 소속 국가지식재산위원회 지식재산전략기획단의 우리 안창용 과장님, 공학박사님 자리해주셨습니다. 안녕하십니까. 어서 오십시오. 어디 계시죠? 네, 끝에 계시네요. 어서 오십시오. 네, 바쁘신 와중에도 오늘 함께해 주신 분들께 감사의 말씀 드리겠고요. 조금 늦게 오셨네요. 우리 삼성 SDS 정윤재 수석님 자리해주셨습니다. 어서 오십시오. 네, 다시 한번 귀한 걸음 해주신 우리 내빈 여러분들께 감사의 말씀을 드립니다. 지금 그러면 본격적인 순서로서 첫 번째 순서죠. 우리 한국저작권위원회 유병환 위원장님께서 인사 말씀을 해주시겠습니다. 여러분들 박수로 맞이해 주시기 바랍니다.
안녕하십니까. 이 자리에 이 뜻깊은 컨퍼런스에 함께해 주신 모든 분들 환영과 감사의 말씀을 먼저 드립니다. 이 뜻깊은 행사 또 저희 한국저작권위원회가 주관하게 돼서 또 매우 영광스럽게 생각합니다. 그리고 바쁘신 일정에도 참석해 주신 박순태 문화체육관광부 컨텐츠 실장님께도 다시 한번 감사드리고 멀리 미국에서 또 방한하신 에벤 모글렌 콜롬비아대 로스쿨 교수님이시자 SFLC 대표로 계신다면 대단히 감사드립니다. 그리고 미시 카우드하리 SFLC 인도시 분야 지부장님께도 깊은 감사의 말씀을 드립니다. 그리고 국내 삼성 SDS 정규 수석님, 충남대 이철남 교수님 오늘 열띤 발표와 토론이 기대가 됩니다. 그리고 그 밖에도 남다른 관심으로 이렇게 컨퍼런스에 참석해 주신 참석자 여러분께도 존경과 감사의 뜻을 다시 한번 전해드립니다. 존경하는 내외 귀빈 여러분, 지금 우리는 문화와 과학과 기술의 진보와 융합이라는 스마트 열차를 함께 타고 달리고 있다고 생각합니다. 빛과 같은 혁신의 속도감을 온몸으로서 체험하는 가운데 과거 자유 소프트웨어 운동이 지향했던 바대로 전 세계의 많은 소프트웨어 개발자들의 생각을 자유롭게 교환하고 사용하면서 보다 새로운 것을 만들어가는 진화의 연쇄 반응을 겪고 있습니다. 인류 모두가 수혜자라고 생각합니다. 산업적으로도 소셜 크라우드, 또 컴퓨팅, 빅데이터와 같은 신규 비즈니스가 빠른 속도로 확산되고 스마트 생태계 역시 정비해지고 있습니다. 이에 수반해서 국내외 소프트웨어 산업계도 경쟁과 변화 또한 격화되고 있습니다. 특히 구글, 또 페이스북, 트위터, 아마존과 같은 해외 글로벌 기업들 모두 이러한 격화되고 있는 소프트웨어 산업 환경에서의 경쟁력을 오픈소스 소프트웨어에서 찾고 있습니다. 이들 기업 모두 오픈소스 소프트웨어를 적극 활용해서 관련 사업과 또 서비스 영역을 확대해 나가고 있습니다. 한국에서도 삼성전자는 스마트폰 분야에서 오픈소스 소프트웨어인 안드로이드를 적극 활용해서 올해 글로벌 휴대폰 시장에서 노키아를 따돌리고 1위의 기업으로 등극한 바도 있습니다. 이처럼 국내에서도 오픈소스 소프트웨어에 대한 활용과 관심이 높아지고 있으며 이를 반영하듯 국내 오픈소스 소프트웨어 시장도 대폭 커져가고 있습니다. 작년 12월 달에 발표된 IDC 보고서에 따르면 우리나라 오픈소스 소프트웨어 시장 증가율 40%로 전체 소프트웨어 산업 시장 증가율 약 7.5%보다 5배 이상의 높은 수치를 보이고 있다고 합니다. 이처럼 오픈소스 소프트웨어는 저비용 또 고효율의 장점으로 디지털 미디어 서비스라든지 인베디드 소프트웨어 산업 등 소프트웨어가 적용되는 모든 분야에 있어서 핵심 동력으로 그 가치를 인정받고 있는 것입니다. 그러나 이러한 오픈소스 소프트웨어의 사용 증가와 함께 오픈소스 소프트웨어 라이선스와 또 지식재산권에 대한 인식 부족으로 인해 저작권 등 법적 책임에 대한 분쟁 발생, 위험 또한 증가하고 있습니다. 따라서 기업들의 오픈소스 소프트웨어 라이선스 관련 인식 제고와 관리 측의 협력을 통한 비즈니스 전략 수립이 매우 필요한 시점이라고 할 수 있습니다. 저희 한국저작권위원회는 국제적으로 오픈소스 소프트웨어 분야의 핵심 역할을 하고 있는 SFLC와 함께 국내 소프트웨어 산업에 실질적인 도움을 줄 수 있는 사업을 펼쳐나갈 것입니다. 2010년부터 제공하고 있는 오픈소스 소프트웨어 라이선스 종합정보 서비스인 오이스와 검사 서비스인 코드아이를 보다 고도화해서 만족스러운 서비스를 제공하기 위해서 노력하겠습니다. 또한 금년 하반기부터는 SFLC와 함께 복잡하고 다양한 오픈소스 소프트웨어 라이선스와 또 기업의 관리체계 구축과 관련된 전문 컨설팅을 제공할 계획입니다. 존경하는 내외 기민 여러분, 또 많은 선진국들이 이미 저작권의 공유와 개방을 통해 국가 창조 경쟁력을 강화하고 있습니다. 우리나라도 소프트웨어를 비롯한 IT 산업의 경쟁력을 높일 수 있는 중요한 열쇠는 저작권의 공유와 개방의 철학을 실천하고 있는 오픈소스 소프트웨어 분야에서 찾을 수 있을 것으로 기대합니다. 아무쪼록 오늘 이 자리에 모든 분들의 지혜로 열리는 국제 컨퍼런스가 올바른 오픈소스 소프트웨어의 활용 문화를 만드는 계기는 물론 국내외 오픈소스 소프트웨어 관계자분들의 지속적인 정보 교류의 장이 되기를 기대해봅니다. 다시금 이 자리를 빛내주신 모든 참석자 여러분께 거듭 감사드리고 항상 행복이 가득하시길 기원하겠습니다. 감사합니다.
네, 한국저작권위원회 유병한 위원장님께서 인상 말씀을 주셨습니다. 좋은 말씀 너무너무 감사합니다. 자, 다음은요, 문화체육관광부 문화컨텐츠산업실의 박순태 실장님께서 축하 말씀을 해주시겠습니다. 역시 여러분들 큰 박수 부탁드리겠습니다.
유병한 위원장님 말씀 잘 들었습니다. 반갑습니다. 문화체육관광부 문화컨텐츠산업실장 박순태입니다. 이번 행사에 방문을 위해 해외에서 참석해 주신 에벤 모글렌 교수님, 그리고 미시 카우드하리 인도지 부장님께 특별히 감사의 말씀을 드립니다. 오늘 국내 행사에 참석해 주신 우리 충남대학교 이철남 교수님, 삼성SD에서 정윤재 부총님, 그리고 자리를 준비해 주신 유병한 위원장님께 다시 한번 깊은 감사의 말씀을 드립니다. 오픈소스 소프트웨어는 IT 기업 및 소프트웨어 산업에서 핵심 성장 동력으로 부상하고 있습니다. 이러한 상황에서 오픈소스 소프트웨어 산업과 저작권의 국제적 흐름을 살피고 미래의 변화를 모색하는 이번 컨퍼런스는 그런 의미에서 대단히 시의적절하고도 뜻깊은 자리라고 생각합니다. 최근 스마트 혁명과 함께 찾아온 개방과 공유의 새로운 패러다임은 변화에 적극 대응하는 기업들만이 생존할 수 있는 그런 시대가 도래하고 있음을 보여주고 있습니다. 소프트웨어 산업에 있어서도 리눅스, 안드로이드 등 소스 코드를 공개하여 자유롭게 활용할 수 있는 오픈소스 소프트웨어 산업이 각광을 받고 있습니다. 세계적으로도 오픈소스 소프트웨어 산업은 연평균 20% 이상의 성장세를 보이고 있습니다. 아까 유 위원장님께서 우리나라는 40% 정도로 그 성장세를 높게 보이겠다고 말씀을 하셨습니다만 세계적으로도 어쨌든 20% 이상의 그런 성장세를 보이고 있고요. 또 세계 각국 정부와 구글, 오라클 같은 세계적인 IT 기업들은 오픈소스 소프트웨어를 미래를 결정짓는 핵심 산업으로 여기고 있다고 합니다. 국내의 오픈소스 소프트웨어 산업도 급성장하고 있기는 하지만 아직 갈 길이 멀지 않나 생각됩니다. 최근의 현황조사에 따르면 매출 100억 이상의 기업 중에서 오픈소스 소프트웨어 사용 기업은 60% 이상에 달하고 있지만 오픈소스 소프트웨어의 관리체계를 구축하고 있는 기업은 10% 정도로 나타나고 있습니다. 또한 오픈소스 소프트웨어에 대한 인식 수준도 100점 기준으로 볼 때 한 27점 정도로 아직까지는 이에 대한 이해 및 관리가 매우 취약한 것으로 나타나고 있습니다. 이에 문화체육관광부에서는 오픈소스 소프트웨어에 대한 올바른 이용과 인식 제고를 위해 오픈소스 소프트웨어사 라이선스 종합 시스템 및 오픈소스 소프트웨어 검사 서비스를 제공하는 등 동산업의 발전을 위한 기반을 구축하기 위한 노력을 지속하고 있습니다. 이번 컨퍼런스가 이 자리에 참석하신 여러분들이 IT 산업 및 오픈소스 소프트웨어의 국제적인 동향과 변화의 흐름을 가늠해보고 또 인식을 높이는 한편 이를 둘러싼 여러 가지 식을 검토해볼 수 있는 소중한 자리가 되기를 바랍니다. 우리 문화체육관광부는 앞으로도 오픈소스 소프트웨어 산업계의 목소리를 듣고 변화를 논의하는 자리를 계속 마련하여 여러분들의 현장의 목소리를 경청하여 정책 마련을 하는데 힘써 나가겠습니다. 감사합니다. 고맙습니다.
네, 문화체육관광부 문화콘텐츠산업실의 박순태 실장님께서 오늘 또 축한 말씀을 해주셨습니다. 힘있는 말씀 감사합니다. 자, 그럼 지금부터는요, 오픈소스 소프트웨어 저작권 보호와 활용을 위한 한국저작권위원회와 소프트웨어 프리덤 러센터 업무협약식을 진행을 해보도록 하겠습니다. 자, 그럼 먼저 업무 협약식을 위해서 우리 한국저작권위원회 유병한 위원장님과 소프트웨어 프리덤 러센터의 에벤 모글렌 대표님을 테이블 쪽으로 모시도록 하겠습니다. 여러분들 박수 부탁드리겠습니다. 그럼 제가 먼저 협약서를 낭독하겠습니다. 한국저작권위원회와 소프트웨어 프리덤 러센터는 상호 우호 협력 관계를 확인하고 다음과 같이 협약을 체결한다. 제1조 본 협약서의 목적은 양측의 업무에 있어 오픈소스 소프트웨어의 공정 이용 활용 기반 등을 위해 관련 업무의 협력과 공동 사업 주관 등을 통하여 오픈소스 소프트웨어의 저작권 보호를 강화하는 데 그 목적이 있다. 제2조 양측은 다음 각 호의 내용에 관하여 상호 협력한다. 1. 오픈소스 소프트웨어의 올바른 인식 제고를 위한 인적, 물적 자원 교류. 2. 양기관 협력체계 구축을 통한 오픈소스 소프트웨어 컨설팅 공동 추진. 3. 학술 기술정보의 교류와 관련 법 제도 정비 및 주요 동향에 대해 공동조사와 연구. 4. 각종 교육 프로그램 개발 및 오픈소스 소프트웨어 저작권 보호의식 대국 및 캠페인 등 홍보. 네, 이하 내용은 생략하겠습니다. 2012년 6월 27일 한국저작권위원회 소프트웨어 프리덤 러센터. 자, 우리 유병한 위원장님과 에벤 모글렌 대표님께서는 앞에 있는 협약서에 사인을 해주시기 바랍니다. 네, 서로 바꾸셔서 다시 한번 사인 부탁드리겠습니다. 네, 오늘 업무 협약을 통해서 양 기관이 활발하게 교류하고 또 공동 대응할 수 있는 계기가 되고 또 함께할 오픈소스 소프트웨어 저작권 보호 및 활용 증진 활동들이 소프트웨어 산업 발전에 꼭 필요한 버팀목이 되기를 기대해 봅니다. 다 하셨으면 여러분들 박수 부탁드리겠습니다. 두 분께서는 기념사진 촬영을 위해서 포즈 부탁드리겠습니다. 네, 이렇게 우리 스마트 환경에서의 저작권 보호를 위한 업무 협약서에 모두 이렇게 서명을 해주셨습니다. 다시 한번 여러분들 축하하는 의미로 큰 박수 부탁드리겠습니다. 네, 감사합니다. 우리 네빈께서는 자리로 이동해 주시기 바랍니다. 자, 이상으로 협약식을 모두 간단하게 마치도록 하겠고요. 이어서 2012 오픈소스 소프트웨어 라이선스 인사이트 국제 컨퍼런스 세션 발표가 있겠습니다. 이전에 공지해드린 바와 같이 총 4개의 세션으로 진행이 될 예정이고요. 동시 통역 역시 함께 제공이 되고 있습니다. 채널 1번을 확인해 주시면은 여러분들 동시 통역을 제공을 받아보실 수가 있겠고요. 4가지 세션이 모두 다 끝난 다음에는 종합 토론 시간이 있을 예정입니다. 그래서 여러분들이 중간중간에 궁금한 점이 있으시다면 미리 체크를 해 주셨다가 잠시 후에 진행되는 종합 토론 시간을 이용을 해보시면 되겠습니다. 자, 그럼 지금부터 본격적인 세션 발표를 진행을 해보도록 하겠습니다. 먼저 첫 번째 세션은 최근 오픈소스 소프트웨어 컴플라이언스 글로벌 동향 및 주요 쟁점이란 주제를 가지고 소프트웨어 프리덤 러센터의 대표이시죠. 우리 콜롬비아 로스쿨 종신 교수이신 에벤 모글렌 교수님을 여러분께 소개하겠습니다. 큰 박수 부탁드리겠습니다.
Good afternoon. It's a very great honor and a pleasure for me to be here. I've spent quite a long time looking forward to the day when I could come to Seoul for the beginning of our cooperation with the Korean Copyright Commission. I want to thank the Commissioner and the Director General and all of his staff for their extraordinary efforts to make our cooperation possible. I look forward to the opportunity now to begin the work that we have together in making the use and improvement and redistribution of open source software not merely an opportunity for us to serve the interests of Korean business and Korean technology, but for us together to improve the technology of the world. I want to begin, if I may, because Thank you. I want to begin because I am a historian as well as a lawyer with a moment of historical perspective on the issues we're going to be discussing today. Copyright law is an amazingly well-adapted system which has been used and improved throughout the world for more than 200 years. But its purpose was the industrial production and distribution of information in physical forms. Beginning at the beginning of the 18th century, copyright law provided the terms on which industries of knowledge, books and maps, and eventually sound recordings and video recordings could be distributed in physical form efficiently by providing incentives to publishers and other industrial producers of information. For this purpose, copyright law is nearly optimal for the production and distribution of information and culture. But we live now in the digital age, an age of such rapid transformation in human history and culture that we have never passed through such a period of adaptation before. And copyright law is under the pressure of rapid transformation. It remains optimal for many of the purposes to which it is applied, and it is actively in the process of adaptation to new purposes and in new material forms for which it is not historically precisely developed. In the digital age, the problem that copyright primarily and brilliantly solves, how to provide correct incentives for the industrial manufacture of cultural and information goods, is no longer the primary issue. If we can make the first copy of something, whether it's a novel or a poem or a computer program or a system of computer programs, if we can make the first copy, distribution is primarily frictionless and costless in the net. As a consequence of this fact, copyright law now serves two purposes, quite different. It continues to provide nearly optimal distribution conditions for the remaining analog articles of information and culture, from textbooks to printed photographs to maps that are printed on pieces of paper and all other forms of traditional communications. But it now also serves the needs of digital industries of culture and information. And in doing so, it requires different rules. This is not a particularly serious problem, because copyright is an immensely adaptable system. Applied to computer software, copyright appears to do the right thing from the beginning. After 1979 in the United States, when a national investigative commission proposed that copyright should be the primary means of protecting intellectual property in software, we have used copyright to protect software as though software were literary work, the work of a small number of authors reserving to themselves all rights to copy, to modify, to prepare derivative works, and to authorize distribution and first sale. This is a consistent and coherent way of protecting the author's interest in software making. It works, but it's not optimal. The optimal form of application to copyright in software is less restrictive and more permissive than the rules which copyright applies as default rules to other literary works. It is easier and cheaper and more effective to make computer software using a less powerful copyright system than the optimal copyright system for other forms of literary work. This is the result of the fact that computer software is a much more collaborative form of information than a novel or a poem or a work of history or even a scientific textbook. Computer software is easier to make if you share the making of it across as many minds as possible. Making computer software is an iterative activity. I design a piece of software. You and 3 other people make a prototype. I begin using it you begin using it, a few other 100 people begin using it, and we find bugs, mistakes, possible veins of improvement, errors in our design, and other reasons to make changes. If each of us is enabled to make the changes we perceive as desirable, and we exchange all those derivative works freely among ourselves, programs will become better, more effective, more accurate, less troubled by errors, insecurities, and design mistakes than if we try, each of us, to implement a perfect solution and sell it as an exclusively owned whole. This fact is a fact about computer software. It's not a weakness in copyright. It's not an ideological proposition. It's simply a fact about how software is made. Over the course of the last 30 years, the proposition we will make better software if we share has gone from being an insight apparent to engineers in a few of the most elite technical institutions in the world, to a fact understood by the largest IT organizations in the commercial IT sector, to a more or less universally understood fact about making software. The collaborative system of innovation made possible by free sharing has spread beyond the software world to other forms of digital culture. In the area of computer software, where we first began applying the rule that less copyright produces better goods, the result was free and open source software and the World Wide Web. The World Wide Web, which is changing all of literate human culture, which is changing television into video and radio into on-demand audio, and newspapers and magazines into websites on your tablet, the World Wide Web is an outgrowth of free software. From the moment that Tim Berners-Lee at the European Research Network, CERN, began making the World Wide Web as a project for improving communication among physicists, the web has been made of free software. The world's first browser, Mosaic, made at the National Center for Supercomputer Research in the United States, became Netscape, which became Mozilla, which became Firefox. CERN's first web server became Apache, which became everything else in the World Wide Web. The same principle that more sharing produces more culture effectively has spread into areas traditionally those for which copyright was optimal: the making of literature, visual arts, and music, through the adaptation of free software licensing to culture by Creative Commons. Combining free licensing of software technology with free licensing of cultural properties has brought us an information economy based around free sharing. The most important such example is Wikipedia, which in all the languages of the developed world is changing the daily life of every literate human being. If you're a teacher, as I am, who has been teaching for a quarter of a century, you know that Wikipedia has already changed how every young person learns and what research means. These information economies of free sharing are crucial to the delivery of knowledge in the 21st century world to all 7 billion human beings on Earth, many of whom will never be able to buy a book or have access to a library, but all of whom can learn. Science has always been a domain of free sharing since the development of modern scientific method in Europe in the 17th century. But now, at the opening of the 21st century, we are taking the very system of free sharing pioneered by software to the open access publishing movement in the United States and elsewhere in the world, which asks for all the research, scientific research, conducted using public money to be made publicly available on terms that permit copying and redistribution. What this means is that society is learning how to get more innovation at lower cost. In many of the societies at the top of the developed world right now, we are living in austerity, in a time of reduced budgets and public debt. This is less important a subject in Korea at the moment than it is in Europe or in the United States, but it is a fact of all our lives because it is a dominant force in the current global economy. And yet, because free sharing is not only possible, but powerfully now incorporated in all our public processes, we are able to increase levels of social innovation even under conditions of decreasing public investment. This is an introduction to the subjects that I now wish to discuss, the subjects of today's conference. I present them to you because I believe that the context of this conversation is the success in using copyright to provide more innovation through less friction, by reducing levels of copyright that were optimal under 20th century conditions to slightly lower levels of copyright protection that are optimal under 21st century conditions. I will offer you a proposition about how to understand open source licensing based upon my 20 years experience as a lawyer working in this area. It is easy to understand these licenses if you begin by thinking about them from the position of the computer programmer, not from the position of the business or user downstream. The computer programmer, or rather the projects combining lots and lots of computer programmers together, the computer programmer is the person who chooses to use these licenses. And we will make our greatest headway in understanding the licenses and how they work if we begin by thinking from the programmer's point of view. What does the programmer want? She wants two things. She wants users and she wants cooperators. She doesn't primarily want money. The purpose is making good software and giving it to people who want to use it. I'm not offering you a speculative conclusion. That's a scientific outcome. Beginning about 15 years ago, we began to be able to ask the people who make this software why they do it, because there were enough of them to study in a scientific way. And beginning as early as the beginning of last decade, at the opening of the 21st century, some sociologists began studying the people who contributed to free software projects at certain locations in the net where free software projects were built. Even at the beginning of the last decade, this was a large number of people. By the period 2004-2005, one such place called SourceForge was hosting more than 90,000 different free software computer projects, which involved the time of more than 65,000 people. On the average, those people were working 10 hours a week or more on each of the projects they were contributing to. So it began to be possible to ask thousands of people why they were spending tens of thousands of hours a week making software to share. Those results, which were first published by my colleague Richard Ghosh at the University of Maastricht in the Netherlands, were eye-opening to people who were unfamiliar with the system. When you asked software programmers, why are you spending time on these projects? Why are you giving away a quarter of a work week or a third of a work week every week to write software to share? The single most important reason given was to have fun. The second most important reason given by thousands of programmers was to improve my skills. The third most important reason given was to improve the technical environment for myself, my colleagues, and my community. In other words, the programmer wants to make good software and to have users who can share and improve it, so that the technology for everybody will be better. This should not be a particular surprise. We all do things because we like doing them, because we like getting better at doing them, and because we want to share our results. The difference was that in an age of digital information technology, we could aggregate all those impulses of all those skilled brains in order to produce durable, powerful, valuable software without significant capital inputs. This was the basic political economy that FOSS licenses were designed to foster. It is a demonstration of the strength and utility of copyright law that with the minor adjustments possible in licenses, copyright could be used to make that system work. The licenses protect three things: the user's right to copy, to modify, and redistribute. The key from the point of view of the person who chooses to use these licenses is to protect users' rights. Please understand that that motive to protect users' rights is at the core of everything the licenses do. As we analyze the relationship between the licenses and other parties in the system, we should remember that the license is chosen by a programmer, the author in copyright law terms, and the author is choosing the license to protect the rights of her users. The protection for the right of copying, permission to copy, you may copy this program, is the fundamental protection for the user's rights. If the user of a copyrighted work has the right to make copies, then that user knows many things are protected in his or her use of the copyrighted work. First of all, she can make as many copies as she needs. If she needs one copy of a program, that's fine. If she needs 1,000 copies of the program, that's fine too. The user has the right to as much of the computer program as she needs for any purpose. The right of copying goes along with the right to modify. The right to modify the program means the right to conduct research and development freely. The user must be able to read the program in the form most convenient for modification. That means the source code. That's why we call these open source licenses, because the user has the right to conduct research in understanding them. She has the right to learn. Learning implies the right to experiment. There are many human subjects you can't learn at all unless you can experiment with the material. Some philosophers, like the great American philosopher John Dewey, would say that all learning occurs through experimentation. I will say this, in my experience of computer science, which stretches back to my first job as a programmer at the age of 14 in 1973, all learning about programming is experimental learning. And the best way to learn how to make software is to play around with modifying existing software. The licenses that provide the right to modify are fundamentally protecting the right to learn. Of course, learning also means developing. That is to say, the right to modify protects research and development. If I can learn from a program, I can improve the program. If I can improve the program, I am improving the technology the program instantiates. I am innovating. The license guaranteeing the right to modify is protecting everyone's right to innovate. The free software license, the FOSS licenses, all also protect the right of redistribution. The right to redistribute is the right to teach. That is to say, I have learned about this program. I have made this program better. Now I will teach you what I have learned by giving you a copy that you in turn can learn from, understand, and improve. Of course, the right to redistribute also implies a political economy. The political economy it implies is that everyone can be in the software business. Everyone can research, develop, and distribute. That means that every user is fully empowered by the software she receives. Again, I urge you to keep in mind that in thinking about the meaning of the license, we begin from the meaning of the license to the person who applies it to a program. When I write a program and I put a free and open source software license on it, I am saying a lot of things in a short document. I am saying, you, my user, have rights. I wish to protect your rights. I protect your right to copy, to use, to conduct learning and research, and to redistribute everything you learn. I am enabling you to collaborate with me, and I am enabling us to collaborate with anybody else who wants to. In order to understand the licenses and how they work, it is crucial to understand the intention of the licensor. That's not merely a particular proposition I'm speculating about. That's a legal proposition. In copyright law, everywhere in the world, as harmonized by the Berne Convention, the intention of the author is the guide to the meaning of the licenses. But of course, we don't think about the licenses only from the perspective of the person who applies them. On the contrary, for the very reasons that the Commissioner has stated in his very capable and very far-sighted opening remarks, we now tend to think about the licenses from the perspectives of the businesses. And what I am here to talk about today is the trends in businesses' understanding of the licenses. There are stages of development in business relation to licenses. And those stages have occurred around the world in different societies at different rates of speed at different times. But the stages are the same. They begin by using free and open source software. Businesses use free and open source software because businesses employ engineers to get results using finite resources. And engineers, being smart people, use free and open source software to achieve the results they are hired to achieve because they are strong, valuable materials that cost nothing to use. So businesses find themselves using free and open source software even before they know it's there. I watched at the beginning of last decade when a single lawsuit brought by a speculative plaintiff called SCO against the International Business Machines Corporation caused a lot of large businesses around the world to get worried all at once. Big banks, big insurance companies. The CEO was sitting in the train or in his car on the way to work, and he read, there's a lawsuit about something called Linux. And he came to work and he said to his CIO, in all sorts of companies, all at once, what's this Linux stuff? Do we use it? And the CIO said, I don't know, boss, I'll go and find out. And later in the day, he went to his various staff units and his team leaders, and he said, are we using this? And they said, of course we are. It's everywhere. How did we use it? Well, we needed it, and we took it, and we put it in, and it's running now, and that's the way it works, boss. It's really great. And later in the day, they had a meeting with the general counsel of the business, and the general counsel said, oh, don't use it. It's risky. And the CIO went back and he talked to his team leaders, and they said, what do you want us to do, boss? Turn off the business? What do you think we're going to do tomorrow? The network won't work. The routers will stop. The domain name servers won't be there. The web will go off. What are we going to do then, boss? How are we going to live without electricity tomorrow? You may think that I'm fooling you, but I'm really not. I went around to many businesses whose names and signs around the world you know in 2004 and 2005, and I sat in those rooms with the CEO and the general counsel and the CIO, and that's exactly the argument that they were all having. Because use happened even without knowing it. Because when good tools are there, they get used. So the first thing that happens in businesses is they use free software. The next thing that happens is they discover that they're using it. This is a very stressful experience because there are lots of responsible, thoughtful, capable people inside those businesses who have no idea what free software is. They've never thought about it like a computer programmer. They're not computer programmers, and nobody ever trained them to think like one. So they read these licenses, and they don't understand what's going on, and they don't know what to do about it, but it's in the business, and they can't get it out. And so they have to think about it, and it's hard. And so they attempt to assimilate the free software they're already using. That's stage 2. In stage 2, they try and learn what's going on. They try to understand it. You will hear a lot spoken this afternoon about governance and why we have to build governance. The conversation why we have to build governance is the music of the process of assimilating FOSS. When an organization begins talking about governance, it has gone from the stage of using to the stage of needing to understand. I'm not going to say that everything that is done by way of governance is necessary to understanding, or even that it improves understanding, but it's a necessary stage on the way to understanding. Of course, I've already given you the clue about how to understand best. Think like a programmer. If you don't know how, catch a 12-year-old, or a 16-year-old, or an 18-year-old programmer and ask her to think about it for you. and she'll explain to you what a programmer wants. A programmer wants users who have rights and can improve. So companies go through the process of assimilating FOSS. I have been through that process with lots and lots of companies around the world, not just dozens, but hundreds. And I have seen them think this through. And so I know a lot of different ways that they can think it through. Sometimes hard, sometimes soft, sometimes good, sometimes bad, sometimes slow, sometimes fast. But in the end, everybody gets to stage 3, which I call here domestication of free software. Now they no longer have to govern in the same way. They are no longer worried about the same things. It has become part of the normal, ordinary routine of doing what they do that FOSS helps them do it. And so they have gone from governing to living with FOSS. That doesn't mean there is no governance anymore. There's governance in families. But families don't spend a lot of time on their governance policy. They just live. They do what they do in the ways they do. In some families, father knows best and runs everything. In other families, not quite so much. But whatever is the way of doing things, it's just how we live. We're used to it. We don't have to ask anymore. It's habit now. Those stages of understanding interact with the licenses themselves. There are, as you will hear from many speakers today, 2 basic kinds of FOSS licenses. One of them we call permissive licenses, although they are all about permission. Examples of permissive licenses run from the simple one-line license that says, here's some software, do whatever you want with it, to more complicated licenses like the Apache license that say, here's some software, do anything you want with it, but don't sue me about patents for using your software, and don't try to get away from any liability you have for putting something in there that doesn't belong. But in all cases, permissive licenses say, do what you want with the software, which most businesses understand to mean you can put private intellectual property alongside this free software and keep your private stuff private. There's another form of free software license, the copyleft or reciprocal or share and share alike license. The most important example of the share and share alike license is the GNU GPL, a license I've spent a lot of my professional life using, thinking about, and improving. The GPL says, here's great software. Do anything you want with it, but whatever you make from these parts, whatever you build using these bricks, use this license for what you build so that everybody else will have the same rights in what you make that I gave you when I gave you the bricks to make the building. Copyleft or share-alike licenses in stage 1 during use time are identical with permissive licenses. If all you're doing is using free and open source software, the GPL is the same as a license that says, here, take this, do what you want. It's when you start distributing modified versions of the program that the GPL begins to change the way you behave. And the way that it changes how you behave causes some businesses to fear loss of their own intellectual property rights. So at stage 1 and during stage 2, while they are assimilating software, businesses are often worried about the GPL. They think it's going to cause them to lose intellectual property rights over their own business's work. So let's look a little more closely at this question of copyleft licensing. The communities that use the GPL have approaches and goals of their own. Let's think about the GPL starting from the way the programmer thinks, as I've already recommended to you. Why does the programmer use GPL? The programmer uses GPL because he wants what he's doing to remain free forever. He's trying to build a community which will build only free software in future. And he chooses the license for his program because he wants users who will improve, who will agree with him that it should all be done in commons. He's saying, I am looking for collaborators of a particular kind. If you want to be in this community, collaborate with me on making more collaboration. If you want to be a user, you don't have to share my approach. I'm perfectly happy that you are a user. You can read the code, you can learn from the code, you can conduct research and development of the code any way you want. But if you're going to become part of the public community, if you're going to give this software to people, you should commit to collaborating on the same terms I'm collaborating with you. That's a perfectly appropriate approach. It's not the only approach. It's not a necessary approach, but it's a perfectly legitimate way to try and build a community. And the programmer who puts GPL on a program is asking for that subset of collaborators. He may lose some collaborators who don't share his approach, but the software will be free forever, and that's what he's trying to achieve. Businesses have approaches and goals to software too. Sometimes they are afraid that the goal of collaborating that way is a collaboration which will harm their business interests. Usually, they're wrong. That's because it's not the programmers inside the business who are making the business's decisions. If the programmers inside the business were the business's decision makers, they would say something like, you know what, boss, that's okay for us. We could collaborate on this software on those terms, because if we do, we will get stronger software and it won't cost us anything of our own. We would be happy there. Linux and the GCCC compiler are two very good examples of very sophisticated programs which everybody has agreed to develop under those terms for more than 2 decades now. That's a really important fact. It says businesses derive real advantage from collaborating. It shouldn't be surprising. They do that in standardization all the time. Let's all agree to share a single way or a single path or a single form of development because it will work well for us. Nonetheless, businesses often have felt that their approaches and goals would conflict with copyleft FOSS licensing. I've spent a lot of time around the world teaching a lot of businesses why that might not be true in their particular situations. But notice that when they worry about compliance with FOSS licenses, they are almost always talking about one question: will the GPL hurt us? They don't worry about complying with permissive licenses because permissive licenses are easy to comply with. The license says, do whatever you want, and the way you comply is to do whatever you want. They don't worry about complying with licenses that are semi-permissive that say you can do anything you want, just don't sue me about patent law, because they either don't sue about patent law or they decide we'll live without the code under the license. It's no big deal one way or the other. When they say they're worried about compliance, they mean we're worried if we use GPL software in our products, we may have to sacrifice intellectual property rights that are valuable to us. We may get caught in a situation where we used some software because it was good and cheap, and now we discover that we're going to have to lose or sacrifice or compromise or impair rights of our own in order to meet the demands of the copyright license. I can understand that worry. I've certainly spent a lot of time talking to people about that worry over the years. All I can say is 99% of the time they don't need to worry, and in the other 1% of the time they need to worry only a very little bit and minor changes fix the problem. This is the reality, and it's not very surprising, because the programmer who put the license on the program didn't want to hurt any business. His goal was to have users and protect their rights. It's not terribly surprising that at the end of the day, it turns out that compliance is a lot less dangerous than it looked. But that's not necessarily the way businesses understand it. They go through psychological stages in dealing with licenses. In stage 1, they're afraid. They think it's going to be a problem, and they worry about it. We've already talked about what stage 1 feels like. Boss, you want us to turn off the bank because the lawyer is nervous? That's stage 1. In stage 2, somebody somewhere has a compliance dispute. Maybe it's them. Maybe they actually get a call from a free software author who says, you know, you're doing it wrong. But usually it isn't. Usually it's somebody else is having a dispute and they read about it in the newspaper. Or they employ a contractor who does something wrong. Stage 2 is the stage at which they find themselves asking, are disputes going to harm us? I will tell you how long stage 2 lasted at the IBM Corporation. 1 week. I remember the first time I called up an IBM lawyer and I said, you have a project out there in the world that has a GPL problem. The lawyer said, okay, I'll look into it and call you back. A week later, he called me back and he said, you were right, we had a problem. We're going to fix it. I said, thank you very much. That was the end of stage 2. Stage 3 is the process of engagement. Now we have gotten over being afraid. We have been through either vicariously or directly the stage of worrying about compliance disputes. Now we're going to protect ourselves against worry. We're going to engage. That means we're going to talk to the people in the projects we care about. We're going to meet the programmers. We're going to talk to the programmers. We might hire some of the programmers. Whatever we do, we're going to recognize that this project is important to our business, and we're going to talk to it. Stage 4 is cooperation. We're not just engaged anymore, we're going to put resources in. We're going to pay salaries to programmers, we're going to make contributions, we're going to upstream our patches or our bug fixes to the project management. We're going to become collaborators too. For those people who are in stage 2, who are worried about disputes, let me state a fact which is important to you. Nobody in the world has ever been sued for non-compliance with a free software license who was communicating with the project that sued them. Never. When we advise people in business how to deal with software compliantly, and the SFLC publishes a GPL compliance guide, we are about to publish its 2nd edition later this summer, we state the first rule of GPL compliance. The first rule of GPL compliance is answer the telephone. If we call you, answer the telephone. This rule is such an important rule that we put it first in the compliance guide because this is the rule that keeps people from getting sued. If we call you, answer the telephone. All right? Once upon a time, we were on the verge of bringing a large GPL compliance lawsuit on behalf of one of our clients. A very large multinational electronics company headquartered in Europe was on our list of companies to sue. We asked them for source code for free software they knew was in their projects. It wasn't that they had accidentally put free software in the middle of some proprietary software. They put GPL software in devices and they knew it was there, and they weren't hiding anything. They just couldn't seem to give the users the rights they were supposed to have. We sent mail requesting source code the license gave us a right to request to 6 different addresses listed in their publications as where to write to us to get software source code. Each one of our 6 letters came back, addressee unknown, post office can't deliver, and we got a little irritated about it. And we were going to sue them. But I thought, I'm going to make one last try. I called the general counsel personally. He was not in Europe. He was on a business trip in Japan. I woke him up at 2 a.m. I said, look, we're going to file a lawsuit tomorrow and your company's on the list. But if you give me your personal assurance that this is going to get fixed, I'm going to take you out of the lawsuit tonight. He said, you have my assurance. I said, okay, you have mine. That's the end of the subject. And we didn't sue. Because we weren't trying to make money and we weren't trying to make trouble. We were trying to get the guy to answer the phone. And when he answered the phone, that's all my clients want. They want engagement. So there's a simple rule about compliance. Answer the phone. What is really going on in the law of free software at the moment has a lot to do with how we put software together, and not so much to do with how we get license compliance. We have been working on a project called Harmony with many companies and many programming projects to standardize contributor agreements. That is, how do the projects collect code? This is very important to businesses at stage 4. When you want to cooperate, when you have employees writing software and adding it to free software projects, you want to remove friction in how you do that. You want to know what the terms are under which your employees can contribute, and the company wants legal understanding that its lawyers can follow about what will happen if they put code into a free software project. So we work to standardize those agreements. Sometimes we do that on the terms we call inbound equals outbound. That is to say, it's all free software, it has a license, we'll take it from you under GPL or Apache or whatever it is. Sometimes we need more complex arrangements. Later this year, I'm going to finish working with the Free Software Foundation to change the way we have been receiving code for almost 25 years now. It will get simpler. It will get easier. It will become more electronic. Businesses will be more able to contribute frictionlessly to free software hosted by the Free Software Foundation, and they will have an easier time understanding the legal situation when they do so. Right now, we spend a lot of time worrying about how to assure compliance. We scan code using systems like CodeEye. What is this program, and is there any free software inside it? This is a valuable activity, but it catches very few of the problems that actually arise. We track how code is put together. That is to say, we improve how each line of code in a free software project is documented. Where did it come from? Who put it there? On what terms? And why? The technology of doing this is built into the way we make software, but we are increasingly encouraging businesses to join with us in making better use of it. We are working, and this is a particular concern of SFLC, we are working to improve everybody's legal assurance in connection with those compliance tools. We are working with code scanning manufacturers around the world to offer legal assurance along with code scanning reports. So you get a report from a compliance engineering tool that says, this is what's in your software product. This is what's connected to what. This is what we found there. We will increasingly work with the compliance tool companies to offer legal assurance products alongside. In addition to your scanning report, you get information that says, we, lawyers who know, offer you a legal opinion about what this report means and what it means for your liabilities. And I expect in the next 2 years we will see a number of commercial parties offering compliance and fulfillment services. You have a product, it includes free software. We will take your source code. We will assure that your source code is what you think it is. We will assure that it builds your product. We will make it available to anybody who asks for it, and at a price, we will give you a legal assurance back that we will handle any disputes that come up. I believe that activity, based on sound technology, careful legal planning, and good administration, is going to become a service companies can buy that will give them a clean, simple interface for the use of free software in their products. Build the product, integrate the software, hand the collateral, source code, and other elements that you need to the fulfillment and compliance party. They will check it, understand it, assure that you are not making a mistake, provide it to anybody who asks for it, and if necessary, at the proper price, give you legal assurance that you will never have any liability in connection with it that they can't help you handle in whatever the way is that the opinion provides. So I'm here now. I've waited a long time, and I'm very grateful for the opportunity. And I ought to close by saying, where are you? The answer, unfortunately, is that many people in the Korean software economy are in stage 1. They're afraid. Some are in stage 2. They have had disputes. They are concerned about disputes. They do not know whether to pick up the phone or not, or what will happen if they do. That's why I think it's so important for SFLC to come and work here, and why I am so grateful to the KCC for the terms of cooperation which will allow us to help KCC to help Korean business to get from stages 1 and 2 to stages 3 and 4. Good compliance process tools are available here. The market is active. The suppliers of compliance tools are smart, motivated, thoughtful businessmen, and they are offering products which are intended to help, but they do not cover the whole distance, and they have not prevented people from overestimating risk. There is a shortage of first-class legal advice. I am delighted to work with Professor Lee. I am delighted that he's here today. I have long wanted to meet him, and it is wonderful to have the chance. We both know that the Korean IT economy could use many more specialist open source lawyers. We make lawyers, both of us. That's our job. We would like to make more. We would like them to be wonderful Korean lawyers, and we would like them to go to work for Korean government and for Chaebol, and to make all of this much more clear to many more businesses. That will take time, but it is a crucial step in bringing everybody to the stage of cooperation and out of the stage of fear. Korean businesses are making wonderful products using open source software, but they're not fully engaged with the projects. We need to help make that happen. And that is SFLC's major work here in Korea. We're going to go from fear to engagement in one step, missing compliance disputes as much as we can. We're going to show why improved understanding of FOSS yields more creative IT brains that can make more innovation more cheaply in the Korean economy. We're going to show why international cooperation in free and open source software subsidizes Korean development, improves economic performance, and creates great technology for the world. We're going to show how FOSS will help dominant Korean firms to go from product building to service platforms, which changes Korea's place in global information technology. We have seen this process elsewhere in the world. We know how it works. This is the most important place in the world right now. Thank you very much.
네, 2012 오픈소스 소프트웨어 라이선스 인사이트 국제 컨퍼런스 첫 번째 세션 여러분들 함께 하셨습니다. 우리 소프트웨어 프리덤 러 센터의 에벤 모글렌 교수님께서 최근 오픈소스 소프트웨어 컴플라이언스 글로벌 동향 및 주요 쟁점이라는 주제를 가지고 발표를 해주셨습니다. 이전에 공지한 바와 같이 여러분들 궁금한 점이 있으시면은 저희가 4가지 세션이 모두 끝난 다음에 종합토론 시간이 있으니까요. 그 시간 꼭 이용을 해주시기 바랍니다. 자, 두 번째 세션 진행하겠습니다. 두 번째 순서는요, 인도의 오픈소스 소프트웨어 정책 및 거버넌스 구축 사례를 주제로 해서 소프트웨어 프리덤 러 센터 인디아 지부의 우리 미시 카우다리 지부장님께서 발표를 해주시겠습니다. 여러분들 큰 박수로 맞이해 주시기 바랍니다.
A very good afternoon to you all, and I'm very grateful for this opportunity to talk here. I do international practice for the Software Freedom Law Center, and in that capacity also take care of its India office. I've been asked to talk about the free and open source software copyright law in the United States, Europe, and India. Why we've chosen these 3 jurisdictions only and not the others is because of 2 reasons mostly. The Berne Convention, which is the international administration of copyrights, says that the applicable copyright law is the law of the country in which the publication first takes place of a work. Most of the free and open source software gets publicized in these jurisdictions, mostly at least. It gets made in a lot of other jurisdictions, but it gets first publicized in only United States, Europe, and India. Also, so far, any of the legal disputes which have taken place, which means any litigation which has happened, has only happened in the United States and Germany. So it is very important to study about these jurisdictions. So, coming to copyright law, the copyright systems have taken the inspiration from mostly 2 forms in the English-speaking world. The statutory form in the United Kingdom and the common law, the judge-made law in the courts in the United States. The second inspiration comes from the moral rights derived from the German and the French copyright systems. These forms have been harmonized into some basic principles over the past 100 years of shared administration of international copyrights. That's what I refer to as the Berne Convention, which provides a basic tool set of how the copyrights have to be administered. Courts, mostly in the countries, have been very, very reluctant and uninformative about the application of copyright law to computer software. Most of the proprietary software infringement issues, the cases which are brought on copyright law, are based on an attempt to determine whether one program is close enough to another program and whether it is infringing upon the other. And thus, it involves extracting their features, determining what is functional aspect of it, and how far close they are so that a ruling can be given that one program is infringing upon the other. However, as it's been probably made very clear in the presentation before me, that free and open source software is about sharing and is fundamentally different from how the proprietary software works. In the proprietary model, the licenses are mostly contracts. These contracts are written to bind the recipients, not to give any permissions or rights, just that, but also to bind them. These contractual terms go beyond what copyright law says. They dictate what you can and what you cannot do. They impose restrictions way beyond the copyright law. However, the free and open source software licenses, as Eben pointed out, have to be analyzed from the perspective of the author of the program, the developer, the person who has written the computer software. From his perspective, as he wants more and more users of this software, and he wants you to give permissions, the licenses are closer to the original definition of the licenses. A license historically has meant unilateral permission. I give you permission to do such and such with the work I have just authored. Now, the primary legal function is to give these permissions under the copyright law. That's what the free and open source software licenses are attempting to do. They are not intended to take away any kind of permissions or imposing restrictions which would go beyond copyright law. Now, free and open source software licenses, that's why I use the minimum tool set which is provided by the Berne Convention. Now, these principles create a unique mode of protection in which you are protecting, but not really protecting by restricting way too much. You are imposing certain obligations, but very few obligations in comparison to how the proprietary model works. As per the Berne Convention, licenses mean what a licensor intended them to mean. So if I am the author of a computer program, and I intended it to work a certain way, and I intended it to be used in a certain way, then that is what I will write in a license. And that's how these licenses got written over a period of few years. Somebody wanted certain restrictions to be put, the others wanted only very, very few restrictions, and then there were the others at the other end of the spectrum who wanted that whatever conditions you received certain program, those are the same conditions you should be passing forward as well. Now, it is important to again reiterate that the applicable copyright law is the law of the country of the first publication of the work. Now, why it gets important is because then you can decide which jurisdiction and what laws will be applicable. Now, the rules of copyright procedure, they are only to give effect to the intention of the licensor. It does not matter how the copyrights get registered, or what exactly has to be done at a copyright office, or whether they are applicable internationally or not, but it is very important to see what the intention of the licensor was when he chose a certain license. Now, false licenses, as I just talked about, whether they are contracts or licenses, becomes important only because the terms matter, and what are you going to use and do with those terms leads to the various stages as in the adoption and free and open source licenses. When we talk about license compliance and we talk about compliance disputes, these disputes are basically arising from not understanding the requirements of these licenses. Now, is it a very crucial issue? That's why it is a crucial issue, because the two models work very differently. The proprietary model requires you not only to do what the copyright law gives them the power to dictate, but also certain additional restrictions. Whereas the free and open source software only want to ensure that you have the permissions which they want you to have, but you also follow the rules of a community or an ecosystem these licenses actually lead to. Now, almost all of the copyright law that has ever been developed so far, as I said, is mostly in the United States or Germany. Now, but these codes were actually given something very new when they were faced with free and open source software licenses. They recognized how these licenses were more adaptable, way more agile to suit the needs of the ecosystem and the community they were helping to perform. Now, mostly, there are on the spectrum, there are three kinds of licenses. There are permissive licenses. In the middle are the semi-permissive licenses. And then there are the copyleft licenses. All these licenses are actually permissive licenses because they are giving unilateral permissions to do a certain act or not. The simplest ones are like the BSD or the MIT X11 licenses, which say to the licensee, here, take my software program, do whatever you like with it. There are no conditions to it. Now, those are the very, very simple permissive licenses. More interesting from a legal point of view are the copyleft licenses. The copyleft is actually a spin on the word copyright, which means all rights reserved. Now, by far the most famous of the copyleft licenses is the GNU General Public License, the GPL. Now, which says, here, take it. Now, you have the freedom to copy it, you have the freedom to run it, modify it, and redistribute it. But whatever you make out of this, whatever I have given you, distribute it under the same terms, under the same license, which is the GPL. Which means, if there is a common pool, there is a commons ecosystem, and you get some advantage out of it, whatever you have made out of it, you're also expected to give back to that pool. So that that pool over a period of time expands and does not contract, which is what has happened with the Linux kernel or the GCC compiler. Now, this idea of a license that applies to not only what you get, but also to what you make of it, is the central legal innovation in the free and open source software copyright law. It did not require any statutory changes in any country's copyright law. It did not require any amendments to be made in any international treaties. It did not require any other formalities which any country had to follow, whether it was any of the jurisdictions I just mentioned or any of the jurisdictions in which the software gets used widely, such as Korea. Now, what it was actually doing was only making a different form of the author's intent to build a commons where you get to use his work as long as you contribute back to the commons from which you take. This is what the author intended, and that's why that author chose certain licenses. Now, in between the permissive licenses and the copyleft licenses, like the GNU General Public License, there are also the semi-permissive licenses, which have a strong commercial interest as they take an intermediate position, which is very helpful to the business. Now, some of the examples are the Apache license or the Eclipse license. Apache software license is a permissive license which lets you what you want to do, provided you follow very few conditions. Eben pointed out to you that, one, you don't sue me for patent infringement, and second, that you cannot escape the liability for anything which you have put and which is not following the conditions it should be following. Now, Eclipse software license is a permissive license, which is permissive as to the products you make out of it, but it requires you to keep and make available the source code for maintenance and approval. In that aspect, it's much closer to the Free Software Foundation's LGPL license or the Mozilla Public License. Now, why these licenses are assumed to be universally homogeneous in application, even though they may not all be drafted for that particular application, is because they are very, very basic. They are only using what the Berne Convention gives them to use. They do not add any further restrictions. They are only trying to give permissions. They are not expecting the users, whether it's the businesses or the private users, to do anything which goes beyond the minimum requirements of a copyright law. So which implies that any jurisdiction which is going to have a copyright system is signatory to the Berne Convention, these licenses can be easily used and adapted in those jurisdictions. Apache software license has become a very important license in the commercial software development, mostly pioneered by IBM's use of the Apache in WebSphere. And even more, especially in Korea, I'm sure you have seen because of the largest, two of the largest electronics manufacturers companies being headquartered here, Google's decision to license most parts of Android under the Apache software license. Now, the general public license, the GNU general public license, has two versions, version 2 and version 3. Now, it has taken two different roles in the world. Version 2 has mostly remained the license for the Linux kernel and also the license of other software which are closely related to the Linux kernel. For example, BusyBox. GPL version 3 has become the license for Free Software Foundation's fundamental tools and a lot of the community distributed software. Its provisions, which require that you allow the users to modify the software in the product, have been a little controversial with the network operators. Because of the installation information requirement in the appliances, we are also able to ensure that the ecosystem stays as vibrant as it was intended by the authors of the license, as well as the computer software programmers who choose to distribute their programs under the license itself. Now, these licenses are copyright licenses. However, the software industry is amidst right now a big patent war, which interferes with the intention of the licensor in terms of usage of his products. However, now how this is going to play out is not going to be at least based on the free and open source software licenses. In terms of the developments in these licenses, in the past few years, there have been no new licenses. To some extent, Software Freedom Law Center has been responsible for this because now there was a place where people could go and ask whatever the legal queries they had and also get counsel and advice about what is the kind of license they should be distributing their programs under. And because we have a center where people can actually tell them that there are enough existing licenses to suit their needs, whatever their needs are, on this big spectrum between permissive licenses, semi-permissive licenses, or the copyleft licenses, that ensured that there was no proliferation of new licenses. Now, coming to something where how licenses act as community constitutions. Now, in our work at the Software Freedom Law Center, we almost advise all the big projects in the world, which are free software projects, on various issues, not just trademarks, not just copyright licensing issues or patent issues, but any kind of organizational issues, etc., and incorporation issues, etc. Now, what ends up happening and what we learn when we interact with these clients is that the licenses here are not serving any other purpose but the purpose of creating a community, an ecosystem in which they want a project to become a property of the commons. Everybody should be able to use it, and they have certain requirements and certain intentions that how that project should be used. So now these licenses are creating their own legal systems. They do use the copyright law. It's not going against any law, but the legal systems they end up creating are basically based on cooperation. They are laying down conditions that this is how in a project the various contributors will cooperate. Various users, whether they are businesses or individual users, this is how they will take the work product, and this is how they will give back. And these are the conditions they will have to abide with. These conditions are bare minimum, mostly related to copyright, sometimes related to trademark as well. But what is important to understand, it's basically a social contract or a cooperative system the licenses are dictating in creating this legal system. It's not a way of telling people to toe the line and these are the only ways to conduct themselves. how relicensing happens. Sometimes a project has been under a particular license, which initially they wrote thinking that is what they wanted. And then the project also discovers down the line that the proliferation and use of the product has become so rampant, and the feedback they have received from various users, as well as the people who are contributing to the project, is that the current license does not really work to fulfill the intention or the purposes they are actually spending their time working on these projects. That's when it actually works in a democratized system. They come to us and ask us for advice about what is the status of their current license in relation to the other licenses. Then they tell us what are their intentions and what are they trying to achieve and how it is different from what they were trying to do in the past. And then depending on what they tell us, we advise them which license would be good for them going further. This is important discussion in the communities because it is a decision which is taken after consultations amongst the community, but also sometimes public consultations are held in which they would like to know everyone who's a user, their opinions. Now, there are other important aspects of it, which, other than the free software licenses, which are the contributor agreements, in which Eben touched upon something like a harmony agreement, which means that one, there is a current project going on. How does it accept code? If you are actually contributing something, you've written some code, you want it to be incorporated in a current project, whether it's the Linux kernel or some other project, then under what conditions that code is accepted? Do you assign all your copyrights to the project or a centralized authority? Or do you license some part of the project? Do you license your rights? Or there are some special kind of agreements the project has already decided that it will accept your code under. These are the contributor agreements which come in different forms. Licensing agreements, sometimes where licenses under which the code is accepted is the same as the license under which the code is released. And sometimes there are assignment agreements, and sometimes there are some other forms also. These are important again in order to understand that the communities which these projects build are based on legal systems which are only to make and facilitate the usage of the product and not to complicate anything further. I was asked to talk about our experience in India, mostly because that's the place where Software Freedom Law Center decided to open its first offices outside the United States. And also because we have been working with various companies for a very long time. India is also, as you know, the leading country in the software service industry, rapidly trying to move and establish itself in the products and solutions industry. However, they did realize that if anybody has to take and make that switch and also become one of the leading companies in the world, then the winner will only be the company which has the closest relationship with the free and open source software communities, for all the advantages which were laid down in the presentation before this one. Eben said that there are 4 stages in any company's adoption of free and open source software. The first stage being fear, the second being compliance disputes, and then engagement and cooperation. In India, actually, just like the way he intends to do in Korea, we skipped the compliance dispute stage. There was never any fear. The Indian system integrators, as well as banks, the federal courts, and the government, they were very, very open to the idea of adoption of free and open source software. There is a state in the southern part of India with 31 million people. It is a completely free and open source software convert. The entire state government runs on open source software. They converted their entire high school education and also the computer education in the higher education area to free and open source software. That's the only state probably which has a master's degree in free and open source software. And that was mostly because they understood that if India has to keep going forward and maintain its leading position in the software industry, their engineering students have to become very, very adaptable and agile in terms of the demands of the time. They understood if they have to make their software engineers really know every important software product which is out there, it is free and open source software which will teach them how to tinker, how to open and learn, how to change what is already there and move forward. They understood that with the usage of closed source software, proprietary software companies and the products they sell, they will never be able to understand how that software is made. And that's why the state decided to convert the entire educational system to free and open source software. And coming to the software integrators or the big companies which were there, like the Tata Consultancy Services, Infosys, or Wipro, they were already using it inside their groups. Tata Consultancy Services is very similar to Samsung SDS because Tata Group is an enterprise which is into various businesses, and TCS is one of the big clients, is also the Tata Group itself, in addition to the Indian government and various European companies or American companies. They were using it inside. They were also servicing free and open source software for their clients. So the usage was very, very rampant. There were already developers inside the companies who were using the company time to contribute to various free and open source software projects. And this was known to the higher executives up there, and they encouraged it rather than discouraged it. Now, so because there was so much of usage, there was not so much of fear, because these developers were the ones who were trusted upon to know how the licenses worked. And as we pointed out, when you actually try to understand how the licenses work from the perspective of the person who wrote it or the developer who's using it, it becomes much more simpler. It also makes it very clear to you that nobody ever sues anyone in the free and open source software ecosystem when there is engagement and cooperation. Although the companies at the higher level were not involved, but the developers who were the users and who were also the ones who were responsible for the use and adoption of free and open source software were very, very clear and very educated on the use of free and open source software. They did understand that they wanted some lawyers and executive training so that this fear, whatever of disputes, is never going to be there. Also, they understood that their in-house counsels have to understand the usage of these licenses and application, mostly because they didn't want to make a mistake. In trying to overcome that stage of the compliance disputes, what they did far ahead was reach out to the experts in the world. Professor Moglen has been an expert on copyright, free and open source copyright licensing issues now for almost 20 years. And they approached him in 2006 when he first went to India to talk about these issues. And then we entered into various consulting agreements in which we taught seminars and we taught various training programs at all these big companies at different levels. Sometimes they were only meant for lawyers, sometimes they were only meant for developers, and sometimes they were only meant for higher executives to understand how the businesses can benefit from free and open source software. And also because the legal aspects were not so much of a concern of the executives, but the lawyers as well as the developers, the executives wanted to know why so much time was being spent on it and how the business is benefiting from it. But with Professor Moglen's experience of working with the other companies, it was much easier to see. So we've skipped from the stage of fear to engagement and cooperation. So much so that you now see actually free software projects which are being developed in India and a lot of contributions coming up from India. There are various engineering schools in which they have annual free and open source software marathons in which they learn how to work on these programs. whether it is the Linux kernel or MySQL or the entire LAMP stack, and they know this is the way to go forward, and this is where the jobs in the future are going to be. So it has become a part of the curriculum in most engineering colleges in India. It is also because the companies are hiring people who have these skills, and the Indian companies have created a job market already in which they get trained, and then they also are available and ready to work in any place in the world. So, and there was another state which is in the eastern part of the country, West Bengal, which learned from the southern state of Kerala and also converted its education system to free and open source software. Learning from this, there was a consultation meeting, as I pointed out, in 2006, and also that time the process of writing of the version 3 of the GNU General Public License was going on, and one of the consultation meetings for public consultation purposes was held in Indian Institute of Management in Bangalore, in which developers from Asia came over, also the professors there, the legal experts as well as the technology experts got together to contribute to what they expected from this license going forward. Now, in 2010, Software Freedom Law Center established an office in India because after having worked in India since 2006, there was a constant demand for the legal services in India. That's why the Software Freedom Law Center's Indian office, which is called SFLC.in, was established. So far, SFLC.in has been very, very closely working with the Indian government's e-governance projects. Now, these e-governance projects have come up with policies on open standards, the mandatory use of free and open source software in the e-governance projects, the mandatory teaching of open source software tools in the high schools as well as engineering schools. This also involves Indian government's actual establishment of a department in the Department of Information Technology, which is dedicated only to open source technologies. They have also developed a national operating system, which is called BOSS, Bharat Open Source Software, and they're also and their approach to software patents is also now being shaped based on these consultation and discussions. The Indian companies do realize what is going on in the world in terms of patents. India does not allow for software patents currently, and that is what the Indian companies would now are realizing that they would want the same regime to continue. So, summarizing everything, what has actually happened in India so far is because of such a large-scale engagement of various developers, whether from engineering schools or from the companies, they have skipped these various other stages and come to engagement and cooperation. SFLC.in on its board also has the Open Source Affairs Head from Tata Consultancy Services, which further establishes their commitment to the usage of open source. And these companies are desperate to find another business after services. And as I said, it's probably products and solutions. So there are these smaller companies which are coming up who are also becoming manufacturers, like the manufacturers here. In India, at least for now, there are 2 handset manufacturers which are completely run only on open source software, and that those manufacturers are also trying to get acquired by these big companies because these big companies are trying to expand their businesses into it. So overall, the way free and open source software looks in India, it's only positive and upswing. And that has been our experience, and we think the way the response to SFLC's work has been in India, it only seems to be going forward. We hope that this little snapshot of what's happening in India appeals to you and tells you what the other countries in the similar area are doing, and also leads to further engagement with the Korean companies to skip the compliance dispute problem. I worked on the compliance team as a part of the Software Freedom Law Center in the first 3 years of my engagement, my working there. And as Eben said, I was very surprised the first time I went and our legal director told us, call them up, ask them what our client wants, which is just to talk, engage, and get the source code, and that would be the end of it. I had been litigating for a very long time before that, and to me it just seemed like the wrong thing to do. Why is there no litigation, and why aren't we going to drag everyone to court, and why is it so simple? Why aren't we going to get big sums of money for this? But those were my instructions. Call them up, try to ask them, reason with them, this is what you want, and tell them why are you wanting this. And if they respond and they start talking to you, then that matter will never, ever, ever go to litigation. And that was my experience as a part of the litigation team. As Eben said, if you actually engage, there's never any litigation which happens, at least from the Software Freedom Law Center and also the various other parties with whom we engage. If there are further questions on this, we would be happy to answer for them, but for my presentation, that is all. Thank you very much.
네, 2012 오픈소스 소프트웨어 라이선스 인사이트 국제 컨퍼런스 두 번째 세션 여러분들 함께 하셨습니다. 바로 소프트웨어 프리덤 러 센터 인디아 지부의 미시 카우드하리 지부장님께서 인도의 오픈소스 소프트웨어 정책 및 거버넌스 구축 사례를 주제로 해서 두 번째 발표를 함께 해주셨습니다. 좋은 발표 감사하고요. 지금부터는 약 20분 정도 브레이크 타임을 가져볼까 합니다. 로비에 있는 커피와 또 쿠키가 마련이 되어 있고요. 아울러 입구에 오픈소스 소프트웨어 라이선스 종합정보 시스템에 관련돼서 소개와 함께 간단한 시연 부스가 마련이 되어 있습니다. 여러분들의 많은 관심 부탁드리겠고요. 그럼 세 번째 세션은 잠시 후 20분 후에 시작을 해보도록 하겠습니다. 고맙습니다.